Good morning, everyone, and thank you for joining me today. The topic that we're going to cover off today is misleading conduct in the context of developing and building residential property. Now, as a lawyer with 20 plus years experience, I've worked in the construction industry with a particular emphasis on residential building, both for developers and for builders. And I've had a reasonable level of experience in litigating in both environments. The other thing that we have to acknowledge is the landscape in which misleading conduct is now litigated has changed significantly post Opal Tower, post Mascot Towers, and the influence in New South Wales of the Building Commissioner. What we are going to look at today, though, is misleading conduct and how it can arise, particularly when developing and building residential property. And I would welcome any questions along the way. I always think it's better if you participate as we're moving through the topics. It's an area where there is a lot of material to cover. We're only going to be able to cover a short burst of what's required to have a mastery of this area. I've prepared a paper with the assistance of graduate Helen Lynn, and the paper gives you some more material, which is slightly different to what is in the presentation, but it'll give you access to the names of a number of the cases that I'll refer to, which aren't necessarily being or aren't necessarily shown in the slides. But just before we get stuck into the content, I'd like to take time to express an acknowledgement of country. I'd like to begin by acknowledging the traditional owners of the land on which I'm making this presentation from, or from which you are viewing this presentation today. I'd also like to pay my respects to elders, past and present. Well, let's get stuck in and look at what we're going to cover off today. Now, we are going to run through in some detail a number of background matters which you might not immediately think they have relevance to the topic area. And in the QA process of putting my slides together, the organisers said to me, look, how does all of this fit together? And quite rightly, it wasn't immediately obvious how all these various factors that we're going to talk about today fit into the topic of residential property development and misleading conduct in that context. So the reason why I'm taking things in this particular order is to get to the building blocks that we need to have in place to be able to understand misleading conduct and its consequences. The other topic that I'll also be looking at is the impact of unfair contract terms legislation. Now, we know the unfair contract terms legislation took effect from November of 2023. Obviously enough, there aren't any cases yet which deal with how it's going to be deployed and what particular terms will be considered to be unfair. But I think it won't be too long before residential building contracts or residential sales contracts attract the interest of that legislation, because they start with standard contracts and are quite heavily modified on a development by development basis. So we're going to look a little bit at settlement agreements, and the context for looking at settlement agreements is whether you can get out of ACL rights or Australian consumer law rights. We're going to look at a High Court decision called Price and Spore, which deals with tolling agreements or agreements to extend the limitation period. We're then going to take a dip into an NCAT decision about a dog. You know, an NCAT is a New South Wales tribunal. The reason why I'm looking at that case is because I think it explains the principles around misleading conduct quite well. We're going to also then look at another animal case, a story about the sale of a bull and a Court of Appeal decision in New South Wales. We're then going to look in more detail at off-plan sales, renovations and representations, and 2 or 3 cases which are directly on point. We're also then going to look at disclaimers and reliance and look at the debate on contracting out and then we're going to look at some practicalities. But please ask any questions that you've got along the way. So let's start by contextualising where we are. We all appreciate that there is a freedom to contract that we have, and that the gold standard is a bargain will be upheld, but there are a number of factors which are also, I suppose, what we describe as vitiating factors in relation to contracts. At one end of the spectrum, where the court will always intervene, we know we've got factors like duress, fraud, deceit, where there's been a lack of capacity or where there's illegality in the performance or the subject matter of the contract. Along that spectrum, though, you've got varying degrees to which the court will intervene. So for negligent misstatement or for frustration, the court may or may not intervene. And when you come to other categories like mistake, misleading conduct or unconscionable conduct, or the unfair contract terms, the court may uphold the bargain or it might not. It will really largely depend on facts. Now, I haven't included on my continuum here where the unfair contract terms legislation sits, because I don't think that we can precisely work out where it sits at the moment. But if I had to have a guess, I think it's probably sitting somewhere in the middle or slightly to the left of that continuum, where a court will intervene. We know the legislation will bite where there are terms which favour one party over another and for which there is no rational or proper purpose for those terms. I think it'll take us a little while to work out what they are, and for the present point in time, the remedies that we have available for misleading conduct and unconscionable conduct in some circumstances are adequate to cover off on what's required. So one other thing which I'll also mention at this point, and if you have a look at the paper, I've reproduced it, is that we're dealing largely with Section 18 of the Australian Consumer Law. And that says a person must not in trade or commerce engage in conduct which is misleading or deceptive or likely to mislead or likely to deceive. It also covers off on a range of other types of conduct like fraud. Fraud will always be caught by Section 18, although we have a good common law remedy in relation to those issues as well. And the other thing that I'll also mention is Section 236 of the Australian Consumer Law that deals with damages and when damages are available. Section 236 says that if a person suffers a loss or damage occurs because of the conduct of another person and the conduct contravened Section 18, then there is the ability to be able to claim damages. Now, the test which is applied in relation to causation is a by test. So was the misleading conduct the cause of the loss? It's slightly different to the contract common law test. It's different to the tort measure. It's really a separate test in relation to whether there has been misleading conduct and it has caused loss which is actionable. So let's start by looking at an interim question about whether you can settle up statutory rights. And I've mentioned here a case called Wardman versus Macquarie Bank Limited, and the case concerned statutory entitlements to be paid. So it was employee entitlements. And there's been a debate for some time about whether you can settle statutory rights. So let's think of the scenario where someone has sued for a loss where there's been misleading conduct, and they then want to be able to settle up that set of proceedings. The policy discussion has always been around, does the misleading conduct provisions in Section 18 prevents you from ever properly settling up statutory rights? Now, what the full federal court did in Wardman was to look at the authorities around this particular topic and looked at the various intermediate court judgments and reached the conclusion that you could settle statutory entitlements as long as the settling didn't involve a modification of the rights. So think of a typical settlement agreement. Someone's being paid money for something, and in this particular case, rights weren't actually modified, but money was paid to release particular obligations. Now, the reason I start with Wardman and this question about whether you can settle statutory rights is because this is part of the debate about whether you can contract out of any of these provisions in the Australian consumer law. And when we look at contracts for sale, or when we look at building contracts for residential developments, there's all sorts of ways in which people try and escape from liability in relation to obligations under the Australian consumer law. We know as a matter of contract, you can contract out of anything, but the Australian consumer law is one of those topics where it's still not clear whether you can contract out of it. But what we do know already is you can settle those rights. So we've had a dispute about them, and you can settle them up with a payment of money, provided there's no modification. A related question, and one which we'll come to next, is Price and Spoor, a High Court decision in relation to a limitation period in a tolling agreement. So tolling agreement seems to be the term which has been adopted from America on extending the limitation period. In this particular case, there was a mortgage agreement in which there was an agreement to be able to extend the limitation period in relation to being able to sue. So if we think of a typical example of where someone might extend the limitation period. So in a residential context, it might be that someone gives a longer term warranty in relation to a particular part of the product. So for example, in building a standalone cottage, roof tiles are a very good example where a manufacturer may give a 20-year limitation in relation to causes of action in relation to the tiles. It might also be that the builder extends the limitation period in that sense as well. Now, what the High Court said in Price and Spoor was, as a matter of contract, you could extend the limitation period because it involved the enlarging of rights of one party over another. The facts of Price and Spoor are not particularly interesting, but the fact that we can take away from this case is that you can extend limitation periods. And so if you're in the process of negotiating a contract in relation to building work or in relation to residential property, then it's clear that you can enlarge statutory rights. Now, there's no questions so far, which could be one of two things. One is, I suppose, maybe no one's listening at this point in time, or we're still waking up, or that I'm covering the topic area adequately. And if that's so, that's great. But please feel free to ask questions as we move along. Let's get on to an NCAT decision called Taylor and Lay. So it's a 2023 decision, and it's the appeal panel of NCAT. There's nothing particularly noteworthy about the case, but it's really the facts and the way in which the facts were applied, which I think gives us a pretty good example of misleading conduct and the way in which a court will approach misleading conduct. It also gives us as lawyers the ability to get in and to look at the various elements of misleading conduct and what a court will do and how we might be able to advise clients when we come to a misleading conduct claim. So in this case, a person purchased a bulldog puppy from a registered breeder. And in the context of the purchase, the breeder had a number of litters, and I think this was the second litter which was going to be offered for sale. And so the subject matter of the contract wasn't in existence at the time that the transaction occurred. Now, that's important that we keep that in mind when we get down the track and talk a little bit more about building and renovating, that the subject matter is not in existence. So there was a number of phone calls between the purchaser and the seller. The purchaser was concerned about the quality of the dog, and we know from dog breeding that it's a random matter. No one can predict what the offspring are going to look like, and so the purchaser asked relevant questions and were assured that the dog who was going to deliver the pups was sound, and that she'd already produced one good litter of puppies. Purchaser purchased the bulldog for $6,000, and a few days after the dog was brought home, there were signs of anxiety. The dog was examined, Bobby was examined, and Bobby was found to have a congenital condition, which meant that it was going to cost a lot for medical expenses throughout the life of the puppy. So the purchaser then sued the vendor and claimed that she would never have entered into the transaction had the true state of affairs been revealed about the puppy. Now, think about this from a misleading conduct point of view. What could the vendor have possibly said to predict what the puppy would be like? All that the vendor could have talked about was the experience which the vendor had with the last breed, and could have made a prediction on that basis. But it is truly one of those cases where no one really knows what's going to happen next, and from a risk point of view, who should bear the risk? Is it going to be the purchaser, or is it going to be the vendor? So the purchaser, as I said, sued and sought $40,000 in relation to damages. The $40,000 was to cover lifetime medical expenses. We've also got another angle that we don't often have with residential purchases residential construction and residential renovation, and that was there was a degree of emotional attachment between the dog and the purchaser. So the appeal panel had to step through the provisions of the Australian consumer law and what loss might arise when a purchase of this sort occurred. So when you have a look at the judgment, start at around paragraph 47 and have a look at the summary that the tribunal gives of the relevant authorities. So they start with the usual case of York and Lucas, and then move on to looking at the very words that were used. Now, one of the conclusions that we often take away from misleading conduct cases is that they really rely upon applications of the law. However, every misleading conduct case is an application of the facts in the particular circumstances of the case. And so what the tribunal found in this particular case was that what was relevant is what was objectively represented by the vendor at the time of the sale of the puppy. It wasn't subjective belief of what the representations made, but it is what objectively the purchaser could have taken away from those representations. So the representations that were made here were that there was a sound breeding dog, and that was the extent of the representations. And the tribunal found that the fact that there had been a representation of that type, that was a sound dog, and that there would be the likelihood of a offspring that was in good shape, was sufficient to found a misleading conduct application. The court, sorry, I should say the tribunal then looked at damages and didn't determine that the appropriate measure of damages was the cost of the upkeep of the dog or the medical expenses for the dog for the rest of the dog's life. The tribunal found that the appropriate measure of loss was the medical expenses which the purchaser had to pay immediately upon receiving the dog, and a second amount associated with the purchase price. Now, the interesting fact here was that as part of the arrangements between the parties, there had been a substantial offer to settle. The breeder agreed to take the dog back and to then recompense the purchaser for a number of the costs which had been incurred. But the tribunal found that none of that was relevant. The tribunal just put that out of its mind. So I can hear you're saying to yourselves, well, what is the relevance of this when it comes to residential building and residential development? The relevance of this is that when there are predictions about what is going to happen in residential building and residential development, you need to look at those predictions and work out whether they are predictions which are actually actionable. So one of the sorts of predictions what we often find in residential building is the time that it's going to take to build, and it's a hotly debated topic. The other prediction which is often made is the cost, what it's going to cost to undertake building work. Now, both those things may or may not be actionable, but they would depend upon the circumstances of the case. Now, I wanted to move on to one more animal example before we get stuck into the actual property cases, and this is a case about the sale of a bull, and the catalogue in this case was concerned with who purchased the who had set up in the sale catalogue a prediction about where the bull had come from. So the catalogue said this particular fellow oozes qualities: clean fronted with plenty of length and thickness. His sire is just breeding the house down. And in the catalogue, there was a disclaimer which said, whilst all care and attention has been paid in accordance with the compilation of this catalogue and the information, neither the vendors, selling agents, or representatives thereof assume any responsibility whatsoever for the correctness, use, or interpretation of the catalogue. Now, in this particular case, a company purchased a bull at an auction conducted by two vendors on their property at Wagga in New South Wales. The bull was listed as a particular bull stud, and there was an issue about the DNA of the bull, where it had come from. For people that are involved in bull breeding, this is apparently very important because this particular bull was known to be a good breeder, and so there was a substantial premium being paid. What happened after acquiring the bull? The purchaser conducted DNA testing, and the testing revealed that the bull was not sired by the bull or didn't have the parentage that was laid out in the catalogue. So the purchaser sued, and the district court found that there had been misleading conduct. The vendors then appealed to the New South Wales Court of Appeal and asked the New South Wales Court of Appeal to consider whether there had in fact been misleading conduct. And it's really the decision of Acting Chief Justice Bell which I wanted to refer to because of the way in which His Honour approaches the characterisation of misleading conduct. What His Honour said at page 664 of the reports and paragraph 22 of the judgment was this, and I'll read this part of the quote because I think it's particularly useful to understand this particular issue. Quoting from His Honour, "So it is with many statements made in everyday life and commerce, that is to say, matters will often be expressed as objectively the case, whereas in reality they will and can only be statements as to a belief or a judgment. In the context of the jurisprudence relating to the statutory prohibition on misleading or deceptive conduct, the distinction drawn between objective truth and a person's reasonable belief in or judgment as to the truth of a particular matter or state of affairs has always assumed importance, although the distinction has traditionally been drawn between the expression of opinion on one hand and a statement of fact on the other." Now, what is really interesting in this judgment, and this is one of the things that we will grapple with as lawyers, is whether something which is said during the course of a transaction relating to the construction or renovation of residential property is properly a statement of opinion or a representation. We don't have any nice, neat law school examples where facts are portrayed in a particular way. What we have on each of the occasions when we're presenting with facts by our clients is a mishmash of things, and it's up for us to determine, is something objectively a statement or is it a representation? And this goes to the heart of liability for misleading conduct. Go back to those couple of examples which I mentioned before about the representations about time and representations about money, then those two matters can fall within either scope. They can be representations or they can be statements of opinion. So how do we tell the difference between the two of them? It's very difficult. And my view is that if something is important and something is an essential part of entering into a contract, then it should be reduced to writing. Now, that's all very good from a theoretical point of view, and we know that not all of our clients will always accept advice or seek advice at the appropriate time. And so it often falls down to us as lawyers to work out whether something is an expression of opinion or a representation. And reading on from the judgment, and this is again Acting Chief Justice Bell's judgment at page 665 of the reports in paragraph 29, in the context of the case law on misleading conduct, there is no relevant difference in principle, in my view, between the expression of opinion and a statement of belief, although the more explicitly the opinion or statement in question is expressed to be the opinion or belief, the more likely it is to have held that character. Absent such explicit identification, the distinction between a statement as to belief and one as to fact may be subtle and masked by the language in which it is uttered. So going back to the facts of the particular case that we're talking about, the sale of a bull, the catalogue, was the words that were used in the sale catalogue thick, soft, easy doing young sire. This fellow is as quality, is clean fronted with plenty of length and thickness. His sires is breeding the house down. With a disclaimer, was that misleading in context? The Court of Appeal found that it wasn't misleading in context, because when you looked at the conduct as a whole, you needed to say what would a reasonable person have thought in the context. So the class of reasonable people here were purchasers of bulls at an auction. The conduct is looked at as a whole, and also there's a disclaimer. Whilst all care and attention has been paid in accordance with the compilation of this catalogue, etc. The disclaimer is very important in determining whether there had been reliance on the misleading conduct. Now, I said at the beginning that we'd cover off whether you can contract out of the Australian consumer law. A disclaimer doesn't necessarily contract out of the Australian consumer law, but it does have an impact upon the modification of rights, has an impact upon whether someone has actually relied on conduct when there is a disclaimer in place. So when you look at the conduct as a whole, the disclaimer is one of those things which needs to be taken into account. So the outcome in this particular case on the sale of the bull, which the Court of Appeal said, reversing the District Court's decision, there was no relevant misleading conduct, because when you looked at the conduct in context, there wasn't misleading conduct, because the people at the auction would have known what the disclaimer meant and what the prediction in the catalogue meant. So again, tying this back to our residential property, when a builder is making a representation about, or making statements about, the length of time that something will take, or what it will look like, or how much it will cost, it needs to be viewed in context. And the context is important when you have an experienced builder whose job it is to build day by day, and you have the homeowner whose sole role is one transaction. You can see there's that power imbalance. And when we look at this in the context of the unfair contract terms, it might be that the unfair contract terms legislation has work to do, but it might be that there isn't any need, because of the way in which misleading conduct cases work, that an actual misleading conduct claim is sufficient. So let's jump ahead then to one of the very specific examples that I wanted to talk about, which is Century Legend versus Rapani. This is an interesting contract, an interesting case from my point of view, because it was a property sale case which was litigated in the Federal Court of Australia. Now, the majority of these types of cases are litigated in the state courts, but here we had the Federal Court looking at the law relating to misleading conduct. So the case concerned the sale of a very high-end apartment. And I say high-end because the apartment was purchased for $9.58 million. And what I've got displayed on the screen there is one of the photos, or one of the renders that goes with the marketing collateral for this particular apartment. So it's not a shabby apartment by any means, and it's not one of the apartments that we've seen talked about in recent times as having substantial defects. What the purchaser did when buying this particular apartment was the purchaser looked at the photos. Now, this photo comes from the judgment. The federal court, as it often does, takes the view that you should include as much material as possible in the judgment, and so this render comes from the the judgment. So in this particular case, in 2016 Century, the vendor prepared promotional materials to be used in the marketing of the development, including scale models and hardbound brochures known as renders. And at this point, I'm looking at paragraph 9 of the judgment. I'm just paraphrasing what is said there because I think it's the best expression of the facts of the case. It also engaged, Century that is, also engaged CBRE to assist with the marketing, and the particular photo, or what has been called the render, which is shown on the screen now, is the one which was used in all of the marketing material. It's what's called the hero render, because it was meant to display the department in its best possible lights. What the purchasers said was, this particular photo, bearing in mind it's one photo, conveyed several representations. One of them was that it was a large open space between the edge of the building and the pool. The inside of the apartment would flow seamlessly to the outside. When constructed, there would be that beautiful flow through, and the building would be built in accordance with design and standards of construction which were reasonably skilled and competent. Ultimately, the misleading conduct which was concerned by this case was whether this render meant that the view that was available from the picture was different to what was actually in place. Now, the judgment, I'll warn you, for when you read the judgment, is quite a dense judgment, because there are lots and lots of facts which the court had to deal with. But in the end, the judgment came down to a handful of things, and that is, was this particular photo misleading in the context in which it was given? And what the full federal court found was that the photo was misleading. It was misleading because it did not represent how the apartment actually looked when it was constructed. Now, the important things to note here are that the render was, as we were talking about before in relation to the puppy, was a prediction about what the apartment was going to look like when it was constructed. It was a statement of prediction, but the context in which it was given was as if it was given as a statement of fact. So rather than saying this is what we expect it is going to look like, the court found that the use of the photo was really an expression of opinion as to what was actually going to occur. Now, this the full federal court found that there had been misleading conduct, and the case has been remitted for the determination of damages associated with the misleading conduct. Now, the case was decided by the full federal court in November 2022, and last time I checked, there hasn't actually been a final judgment in the case. It'd be very interesting to see what the full federal court says about this case. So what do we take away from this particular case? Well, in the context of off-the-plan sales, then a photo like this is going to be a statement of prediction about what it's going to look like. So if you're in the context of acting for the vendor, or you're in the context of acting for the builder, one way practically in which you can negative the effect of this being relied upon is to include sufficient disclaimers that are precise. Now, there will be some attention between disclaimers and wanting to include sufficient information to be able to get a sale. But if you want to avoid the situation which Century Legend found itself in, then you're going to need to have provided more specific information about the apartment and what it's going to look like in context. As I said before, these cases are very fact dense. The judgment runs to some 230 paragraphs and some 91 pages. And it is that context which is very important. I also now wanted to talk about another off the plan sale case, and this time a New South Wales single judge decision in Lonergan versus JQZ11 Proprietary Limited. Again, this is a case about what was conveyed by the inspection of the property that was made by the purchaser. So, as is typical for this particular type of development, a display suite was prepared. And in the display suite, there was a mock-up of what the apartments were going to look like and what they were intended to be at the end. Now, a display suite is something which is very, very common in this particular space, and the display suite is used for two purposes: one, to sell properties, but also to give the builder a benchmark from which to work. And so the builder can assemble all of the finishes in there, and they know, well, this is what the apartment's going to look like when it's finished. So the Lonegans came and inspected the display suite, and there were a free-flowing outlook. There was no privacy screen, and there was no air conditioner sitting on the balcony in a particular location. When the contract for sale was entered into, there was a disclaimer in the contract for sale, and the disclaimer or the disclosure said the purchaser acknowledges that the vendor has made available to the purchaser inspected or not inspected its own election, the disclosure material. So it's a very typical contract here where the vendor has asked the purchaser to acknowledge that they've had everything made available to them in terms of inspecting the apartments and having made available to them information which they would need to know to be able to purchase. The court then went through the evidence in some detail to determine whether there had been misleading conduct. So the agent, who was the sales agent, was called to give evidence and was taken through the circumstances in which the purchasers had purchased, and there was evidence about what was said at the display suite and what was done, and what was important and what was one of the determining facts in this case was that there had been a degree of communication between the parties about the very issues. So in this particular case, Mrs. Lonergan had some medical conditions, and she was concerned about having sun on her, and so the existence of a privacy screen or a shade screen was very, very important. And that was one of the factors which she took into account when deciding to buy. When she actually purchased the displays, that privacy screen wasn't in place. So, having gone through at great length what was included in the apartment and what wasn't, the Lonegans went ahead and purchased, and then it was different to what they inspected when they came to their final inspection. Again, in a very fact-rich case, the court looked at whether in context there had been misleading conduct, and that context included whether the comments that were made as part of the sales process, and whether the disclaimers in the contract had work to do in negating the apparent misleading conduct. So what the trial judge did was to step through each of these facts, and then at paragraph 173, and this is where I'd suggest you go and have a look, there is a very, very good statement of the legal principles, which ties together a number of the cases that we've already looked at, and also looks at Ireland and Riverview and the context in that particular case of whether what was said by the agent was misleading or whether it was deceptive in all of the circumstances. What the court found was that there had been misleading conduct and that the transaction should be undone. And the case, which was decided in October 2022, is a real wake-up call for people who are involved in renovations or building, because when you look at the case, you would think as a lawyer, what could I have done to advise the developer differently? The developer seemed to have done all the right things, had all the relevant conversations, had all of the relevant disclaimers in the contract which were possible, and yet still the court was prepared to find that there'd been misleading conduct. What I think this particular case means for both builders and for developers is that you have to be careful each and every time that there are representations or statements of opinion which are made about a property, because courts will from time to time, as they did in this case, side with consumers. I think the other issue here, the unfair contract terms in particular, is some of the contracts for sale and some of the building contracts that we see are so complicated, often based on standard forms, that I think courts will, in due course, intervene in those contracts and find that they fall foul of the unfair contract terms. So let's just have a brief recap where we've got to. We've worked out that you can't contract out of the obligation. We've come to the point where you can extend limitation periods, you can settle misleading conduct claims. There's a degree of liability associated with representations and statements of opinion, although each will come down to matters of facts. The other factor which needs to be considered in all of these cases is causation, and what it was that caused someone to enter into the contract for sale. And in Lin and Zeng, a New South Wales Court of Appeal decision from August of 2023, the Court of Appeal found that causation is to be considered in a common sense way. So that if a material representation is made which is calculated to induce someone to enter into contract, and that person in fact enters into the contract, there arises a fair inference of fact that he or she was induced to do so by the representation. So going back to the Rapani case that we just referred to and Lonergan, what the New South Wales Court of Appeal said was we can infer that there is reliance, and causation is then considered in a common sense way. If someone's entered into a contract after there's been a representation, the starting point almost is that the court will consider that there has been a representation which has caused entry into the contract. Now, that doesn't always mean it's misleading, but the representation has founded the entry into the contract. We often hear the word reliance used when we talk about Australian consumer law claims, and interestingly, the word reliance does not appear in either Section 18 or Section 236. So when people propound misleading conduct claims, they often say, well, they relied upon the misleading conduct. But what needs to be considered all of the time on misleading conduct cases is it is not reliance which is the important factor, it's the test by. So did the misleading conduct cause the loss? Was it caused by? Was entry into the contract caused by the misleading conduct? Now, in this particular case of Flog Engineering and Blue Logistics, there was a concern about milk tankers and particular flow meters on the milk trucks. Whether there was misleading conduct was a question of complete context in the case. So no one specifically said, here's a representation for you. There was a lot of context in the transaction, and it was the context in which the misleading conduct had occurred. So if you have a look particularly at paragraph 53 of the judgment, you'll find that in this full federal court decision from July 2023, it is the context which was important, and that was the real issue in the case, is that the misleading conduct arose from context. So let's tie this then back to our misleading conduct in relation to off-the-plan sales, building and renovating residential property. Those statements of opinion which are being given about how much, how long, the quality, whether it's buildable, all of those matters may be misleading conduct, but context will be everything in the context of whether a misleading conduct claim is available. Now, we're coming towards the last 5 minutes of the presentation, so if anyone's got any questions, please bring them forward now. Otherwise, I'll keep talking for the last 5 minutes and cover the balance of the material that I was going to cover. The other thing about reliance, which I was going to say, is that it often requires someone to put in place a counterfactual scenario. So what would have happened but for the misleading conduct? And let's think about that in the context of renovating a property or building a new property. If there hadn't been misleading conduct, what would have happened? So if there hadn't been misleading conduct, for example, about the price for the renovation, would someone have never entered into the contract? One of the things we find about in suing professionals for misleading conduct in the context of building is that professionals, and particularly some people like architects, will be able to escape liability because they say, we are not here to predict price. Our role here is to predict design only, or to create design only. So we might tell you something about price along the way, but that's just merely an expression of a thought, not a representation. Another factor which I'll briefly mention is the context of trade and commerce. So you remember at the beginning of the presentation when I started talking about Section 18, and we said a corporation shall not in trade and commerce engage in misleading conduct which is likely to deceive or likely to deceive. For the Australian consumer law to kick in, there has to be a transaction in trade and commerce. So most of the time, when we're dealing with builders or professionals, it will always be a transaction in trade and commerce. But if you're buying, for example, for a government instrumentality or a government, semi-government organisation, it may not necessarily be in trade and commerce. It might be that government is fulfilling a statutory role. Now, I only briefly reference that particular topic because it's important when you're considering liability. The last topic that I wanted to talk about very briefly was the debate on contracting out of the Australian consumer law and the role which I think unfair contract terms legislation will end up having. In New South Wales and Victoria, there's been several statements of opinion by intermediate and appellate court judges about whether you can contract out of the Australian consumer law. And the debate has not resolved that position. In some states, the position seems to be that you can contract out of the Australian consumer law, and in other states, you can't contract out of it. Why is that important? Well, I think when we come down to talking about the unfair contract terms legislation, if the Australian consumer law doesn't bite, then the unfair contracts acts will, because they will, I think, take up some of the slack in positions where there hasn't always been a nice, neat remedy under the Australian consumer law. Now, I've got a question here from John. The question from John is, do you have any views on legislative extensions to deal with the very common issue of non-negotiable, harsh or unconscionable contract provisions, especially in the off-the-plan sales? I think it's difficult to speculate on that topic, but I will speculate on it anyway. I think it is. I think some of those terms which are expressed to be non-negotiable will be caught by unfair contract terms legislation. When you look at the context in which the off-the-plan sales cases work, which then leads on to building, there is often no ability to be able to negotiate any of the terms, and so it ticks a number of those tests that you need to attract the legislation. Now, whether it's necessary to protect the interests of the vendor or not, it probably isn't. I think there's a lot of developers will have to modify behaviours to be able to comply with that legislation. There hasn't been too much debate on that topic that I've seen in cases or in articles, but I think that is something which won't take too long to come up. We've also, in this context, need to look at the interplay with other rights, particularly in relation to residential building. It's a very, very regulated market, probably even more highly regulated in New South Wales than it ever has been. And when you have a role, for example, like a building commissioner, as we do in New South Wales, there is, I think, going to be little room in the future for developers to be able to get away with the sorts of conduct which they've been able to get away with in the past. In the context, though, of contracting out of the Australian consumer law, we're going to have to wait, I think, until the High Court makes a decision about that topic. And I don't think it'll be too long before we reach that position. In a New South Wales decision called GNS Engineering Services and Mac Energy, highly litigated piece of material or case, which is, I think, on for final hearing later this year. That issue, I think, will arise, and I think that will end up making it into the High Court. Now, we've reached 12 o'clock, and that's my hour taken. And unless there are any other questions, then I'd like to thank you for your attendance today. And I'd like to just very briefly summarise with where we've got to, and that is, I think that the current case law, current legislation that we have in relation to misleading conduct, and probably to a lesser extent unconscionable conduct, which I haven't covered off on today, gives most people the ability to be able to sue for any conduct which is misleading or deceptive. However, the thing that we need to remember as lawyers is that each of these cases is going to come down to a question of fact, and for anything that's particularly important, to the extent that our clients can, our clients should put things in writing, even if it's not done in a lawyerly way, anything which gives contemporaneous evidence of what took place during a transaction around renovation or around the building residential property is going to be very, very important in terms of expressing and finalising liability. Anyway, thank you very much, everyone. That's where I'll leave my presentation today. There's the slides and the paper that goes with it, which should give you a little bit more detail if you need it. Thank you.